All right, everybody, welcome back to the Learning Out Loud podcast. I'm your host, Dustin William. I have my co-host with me, Whitestone.
It is undeniable that a vast proportion of the actual doctrines and rules which make up the system of equity are necessarily inferences from or direct applications of some or more of these fundamental maxims.
The power is neutral. It's sitting in the quintessence until you invoke it. Behind using these things are good and holy and Christ-like.
I shall now attempt to show how the most important of these principia have been crystallized into the pithy form of maxims and have influenced and developed that grand system of truth known as equity jurisprudence.
All right, welcome everybody back to the Learning Out Loud podcast. This is episode 9. We are continuing our exploration into Murray F. Tuley's speech that he gave in 1903 to the Illinois Bar Association that he was the president of in that year. And we are actually to the end of the document, so I guess I'll explain how these next couple of shows are going to go. So what we're going to do today is we're going to do things a little bit out of order if you're reading the document and following along at home. We are actually going to, because we're in the order, we're on page 37 going through the shows, but we're actually going to skip to page 44 and read till the end of the document for the first hour here. And the reason we're going to do that is because I'm trying to entice you guys to the website, truelifeproduction.com. And so you guys can get access to the second hour of the show, and because we are going to get into a very critical equity case that we found this week, and me and Whitestone here are very interested in. And speaking of, let's introduce our co-host, Whitestone. How's it going, man?
I'm doing great. I say this about a lot of cases, but this is one you're definitely going to want to study because there's so many gems in here that touch on a lot of auxiliary issues. It's great to study these.
Yeah, and these two shows are going to be kind of specifically geared towards all of these people out there in the quote-unquote law community that are obsessed with the federal rules of civil procedure and say that's the only way for anything and blah, 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 and all of that stuff. Well, this case that we found here is going to show you that you are I'm sorry, I don't know how to put it another way. You're wrong. So equity's never changed. Even they even talk about it in the case post-merger. This is not a case you're gonna want to miss. The case is there provided. It's about 35 pages. You can read it in a day easily. And we're actually going to do a show just on this case down the line a little bit, because all the cases that they talk about in here we could pull out and we can go through the actual rules of civil procedure that they talk about and how it's all relevant and really lay our case down for that. But before we get there, let's start getting back into Tuley's speech. Oh, sorry. Before I want to explain the next two shows, because this show is that case is going to be really important into our point here, and then this show is gonna finish up Tuley's speech, and then what we're gonna do for our last free show on episode 10 is we're actually gonna go through the first 3 chapters of Joseph Story's Commentaries on Equity Jurisprudence. And the reason I want to do that is because in order to really understand equity and this whole thing that we're talking about right here, I think it's not just essential, it's mandatory to understand the history and how these courts work, because all I see online all day is I don't trust the judges. Why would I want my case sealed? And blah blah blah. And the whole framing of what they're talking about is what they actually deal with in a regular court, which is an Article 1 court. It's not an Article 3 court. All of the courts we deal with now are Article 1. Yeah, go ahead.
And they have a right to be. They don't really know where they are. They have a right to be suspicious because yes, a lot of arbitrary decision making and discretion is used on that side, and it's not according to equity doctrine. So, people would have a right to be suspicious because, yes, it is arbitrary, but what they don't understand is that the merger never did away with equity. It simply merged the venue and the jurisdiction, but did not do away with the equitable remedies or the jurisprudence
Or the substantive rights,
or the substantive rights.
as we will learn about later. If you want to learn more about that, you got to join us on hour 2, and we will prove that through a Supreme Court decision. It's Anton Scalia. If you know anything about that guy, do you know anything about Scalia, Whitestone?
No, not in depth, no.
Okay, well, Scalia, the more I learn about this guy, the more I like him. And he was actually murdered for one of his Supreme Court cases, for one of his decisions that he gave pertaining to gun rights in the Second Amendment. He was murdered for that case. You can look up the story.
Don't want to
And
say.
yeah, no, yeah. So but he was obviously a great man and did what he thought was right. And everything that I read from this man, he also wrote a book called Reading Law, the Interpretation of Legal Text, which you can also get on my website through the Article 3 articulation section and go visit all aboard while you're there. But you can read his book, Reading Law, the Interpretation of Legal Text, which is it's a great text to read because it does teach you how to read these legal texts and understand how to read Supreme Court decisions better, and goes into textualism and grammar and all this stuff. And actually, once we get done with our law series, we're actually going to go into a trivium series where I am going to do my best attempt to bring in Scalia's book and give it context in the trivium method of learning, which I'm really excited about. So, but before we get to any of that, let's just start with going right ahead and reading this speech into the record again. And there's a lot of gems in this. There will be a lot of gems in this first hour too. The end of the speech is really good, so I'm excited to get into it. So, with no further ado, I'm going to start here on page 44, paragraph 1. Equity maxims and the laws of reason. The equity maxims taken as a whole, regarding them as principia, the foundation stones upon which the magnificent system of equity jurisprudence has been construed, would seem, for any chancellor having the high sense of morality and purity of character, absolutely necessary. One who by study has become able to grasp the great scope, extent, and power of these maxims, and is thoroughly imbued with the true spirit thereof. Sufficient of themselves for the performance of the duties of his high office, he would need only these maxims to exercise the authority which was granted to the early chancellors by the decree of King Edward III, to decide all controversies upon the principles of equity, honesty, and conscience. We have already referred to the fact that equity as administered in early times was largely borrowed from the equitas as administered by the Roman magistrates. The extraordinary jurisdiction of the civil law took for its guide the lex natura, or as often called, the law of reason. It was termed equitas from equality, because such law was supposed to be impartial in its operation, applying to all persons alike. The early English chancellors borrowed from the civil law some of its maxims, which Lord Bacon tells us were more like proverbs than maxims, and the moral principles which he found in the equitas of its extraordinary jurisdiction, but also influenced by the great moral principles of the religion. They brought their Christian spirit to bear in the formation of the rules and maxims which should govern them in the administration of equity. They also applied what is termed the natural law of reason, not only to the controversies between man and man, but also to men in their relation to society and the body politic. The same power of reasoning which gives man laws for governing himself and all inferior creatures gives him laws also how he should deem himself in the grand and universal society of the world, end quote, says Dawson in his Origins of Law, published 1693. Among the laws of reason, which he alleges should govern should govern men in their relations to each other and the body politic, he enumerates several a bare reference to which would indicate to what extent the Roman magistrates, in exercising their extraordinary jurisdiction, and our early chancellors in erecting this new system of equity, relied upon the natural equity inborn in man's reason, and applied the same uninfluenced by precedent to soften the rigor or prevent the injustice of the law. As laws of natural reason by which man should be guided and governed, he gives, quote, one, that all men are to be looked upon as equal one to another, that no man can be so mean or despicable as not to have a just claim to common right, end quote. This is equality indeed. Mr. Hooker, he says, makes the foundation of the obligation mutual love among men and derives from it the great maxim of justice and charity. This law of reason led to the great maxim that equality is equity. Certainly, this natural quality entered into several of the maxims of which I have spoken. Um, yeah, that's a great little passage there. And I like how he's touching on the laws of reason, which go back to natural law and which also go back to the trivium method of learning. Because reasoning things is the whole logical aspect of the trivium method. You start with grammar, gathering all your data, and then uh, you go to the logic phase, where is you correlate all the data and reason it out before you head to the rhetorical phase. Um, and I'm actually going to try and connect this in our Trivium series too. But it's just we were just talking about this earlier too, how you just can't change the laws of nature, no matter how much they want to or how much they try. They can erect 60 million codes and statutes, but no matter what, the laws of nature will never be changed.
Yeah, they can't eviscerate natural law by, a merger in 1938.
Right.
One thing I really like about this passage as well is that all men are to be looked upon as equal to one another, and that no man can be so mean or despicable as to not have a just claim to common
Hmm.
right. So that means that no matter who you are, you absolutely do have a right, even if you are a despicable person.
Yeah, and that goes back to the clean hand doctrine. It doesn't
Yep.
matter how despicable you are, as long as your hands were clean in this case, you can still get equitable remedy.
Yep. Wow. All right. Did you have anything that you wanted to kind of provide commentary on for your portion?
No, I think that's about all I want to add to that.
I mean, it's pretty cut and dry. This stuff doesn't really
Yeah.
require a whole lot of interpretation.
Yeah, as we go through the speech, yeah, we'll probably have a couple little breaks and we can talk towards the end. I think he also talks about the merger stuff towards the end, so I think we'll have a lot to talk about there. But yeah, it's the way he does this speech. I think it's just pretty self-explanatory, and I suggest everybody read it on top of listening to the show too.
Yeah, this speech was a groundbreaker when it was discovered.
Yeah,
Just for a lot of the people out there that are at the forefront of discovering, equity and kind of the way that the system works, have looked at this speech as probably one of the biggest eye openers. So for anybody that wants to, please get your hands on it.
and it is provided on the website for anybody interested. So,
All right, so we'll continue on. Another of these laws of reason that Dawson gives is, quote, no man as a citizen of the world ought to arrogate more to himself than he is willing to allow others, end quote. Is not the maxim that, quote, he who seeks equity must do equity, founded upon this law of reason? Another law of reason that he gives is, quote, that no man ought to do any hurt to any other man, end quote. The spirit of this law of natural reason must have influenced the laying down of the maxim as given by Francis, that, quote, he that doeth iniquity shall not have equity, end quote.
hmm
I quote another which Dawson gives as follows. Another law of reason is that equity be used in the distribution of justice. For all men being equal, as they are men, it is plain that a respecting of persons must be a derogating from him who is postponed or less regarded than another. Equality as between suitors as persons, equality before the law, by the law and under the law is as much a principle of equity as that of equality of rights between them is a principle of equity. Another law of reason that this learned author gives is peculiarly applicable at the present time, that no man ought to be judged in his own case, and that it is a law of nature that two contending parties refer the question of right to the arbitrament of some third. With all our boasted civilization and our rules of law and equity, the result of centuries of improvement and growth in the administration of justice, and with all our greatly advanced civilization, we are at this time confronted with questions of right and equality arising almost daily out of the complications between capital and labor, for which no system of jurisprudence, neither of law nor of equity, can furnish a remedy. Even the effort of, quote, government by injunction is found to be inadequate, and we are forced to resort to that law of nature mentioned by Dawson, that where there are two contending parties, they shall refer the question of right to an arbitrament of a third. Wow.
Yeah. Yeah, that's a good little.
Even the effort of government by injunction is found to be inadequate. I love that.
Yeah, which is it goes right along with the case that we're going to talk about later, because that's basically what they were trying to be. Um, yeah, oh shoot, what was the other part I wanted to hit in here? This the arise, yeah, we're at the time confronted with questions of the right arising almost daily out of the complications between capital and labor, for which no system of jurisprudence, neither of law nor equity, can furnish a remedy. Um,
I wonder if
and
it's, sorry, go
Go
ahead.
ahead. No,
No,
no, go ahead.
I was just thinking out loud, because, if equity is biblical, and there, he's even stated in here that equity really cannot furnish a remedy for the complications between capital and labor. Does that not say that the whole relationship of capital and labor is inherently like either doomed to fail or built on something that is not equitable?
Right, right. And yeah, and I think that's yeah, I would say that that's definitely the point he's trying to hear here. And 'cause and that I'm trying to word it right because I think this goes back to maybe the whole birth certificate thing too, and why the only way we can get equitable remedies is through the specific process that we follow. And because in my I don't know, I guess in my interpretation that would be an issue between capital and labor. Maybe not though. I'd really have to flesh that out to see how I really feel about that though. Maybe I shouldn't bring it up right now. So,
I mean, if you think about it, in capital, the relationship between capital and labor in the context of where we live is, the employer-employee relationship, which is,
right.
it's commercial. It's all paper and fictitious entities and commercial.
Hmm.
And I'm just wondering if, because that entire system of capital labor is built on it being commercial, the non-physical realm, um, I guess what you want to call the shadow realm, equity can only do
Mm.
so much because it's based in shadows.
Yeah.
I mean,
Yeah.
that's,
Well, and then maybe we have to use equity to shine a light on it. Maybe that's the whole
yeah, and
point.
that's the thing. It's like,
Yeah.
because with capital labor, you're basically subjugating yourself to another for, a little shavings of money.
Yeah. Yeah.
So
Yeah. A little shavings. That's a great way to put it.
yeah,
That's definitely what it
little
feels like
penny
today.
savings of money there. And so I'm just trying to figure out what it is that he's pointing to when he's saying that, daily there's complications of right, between capital and labor, and no system of jurisprudence, law or equity, can really can give a
Can really
remedy.
give
So I
it.
wonder if it's like, well, it's inherently contentious, the
Well,
whole
and you
relation.
know what's interesting is right, this is 1903, so that's when J.D. Rockefeller's really taken over the freaking world right there too, and J.P. Morgan, all the robber barons. So maybe he's talking about something really specific there.
Yeah, it could
Interesting.
definitely be an era, a time period specific reference where, the late 1800s, early 1900s, there was a massive shift happening. Industrialization was fairly well taken root. You had people learning how trusts work, and
Hmm.
they're teeing up in 20 or 30 years to basically take over the whole system. So
Yeah, it's a really interesting time. I'm listening to Chernow's book on JD Rockefeller right now, which I fucking Ron Chernow. He's such an apologist for these people, but he's got great information in the books that you can really expand your knowledge off of.
yes,
But yeah,
sometimes
it's really interesting.
sometimes the only way to learn about something is to listen to the apologists, because you know
Yeah, you got to know their side of the story just as well. You need to
they're going
know
to tell you
yours.
what they're doing, but they're going to apologize for it. So
Right, exactly. Exactly, and that's exactly what this book is. It's hilarious. All right. All right. So we'll move on to the next section here. Um, yeah, we're on page 46 now. So equity and purity are synonymous terms. That which excites the admiration and love of the good chancellor for the maxims known as equity maxims is the pure and high standards of morality that pervades them as a whole. How could pure equity, impartial justice have for its foundation aught but the purest morality? And we talk about that all the time. Unless we accept the teachings of the man who speaks as never man spoke before, no moral code that was ever promulgated to the moral man ever exceeded the sublime, pervading inherent purity contained in the principles of these maxims. There run through these pure maxims that spirit of love, equality, and the brotherhood of humanity, which the early chancellors imbibed from the teaching of the meek and the lowly Jesus, to whose service their lives were devoted. They incorporated these maxims into equity jurisprudence. Through through open the doors of equity to the rich and the poor, and the lowborn, the beggar, and the lord, without distinction as to person or caste, and applied to the maxim equality is equity, without fear, favor, or affection. The laws of nature and of God teach the doctrine of equality. Does not the command, he who seeks equity must do equity, partake of the spirit of the divine command, do ye not, or do ye unto others as ye would that others should do unto you? And yeah, I know that's a short little section right there, but we've said that. I mean, how many times have we said that in earlier shows that really the equity maxims are exactly the golden rule, and that's exactly what Tuley just said right there.
exactly what they are. Equity is just the word they use to describe that entire system of behavior, which is righteous.
Mm-hmm. Mm-hmm.
So, I
Yeah.
had actually, before we actually got into the speech and we're recording it, I had read the whole thing through, and I'm now coming to a lot of my paragraphs and things that I highlighted. And this next section, I have the entire thing redlined.
Oh,
So,
nice. Nice. Well, I got you up for reading it, so you can
great.
go ahead and let her rip.
That's how it works out. So,
Yep.
all right, here we go. And I have this entire paragraph underlined very heavily.
Okay.
Equity proceeds upon the presumption that all litigants are honest, that everyone
Mm,
intends to do right. While it abhors fraud, it never presumes fraud, and unless fraud be clearly proven, the presumption of honesty and good faith must prevail. For does not the maxim declare that equity will impute an intent to fulfill an obligation, that honesty is equity? Also, is it not a favorite maxim of equity that impartial justice will be administered upon the principle of treating that as done which in good conscience ought to have been done? In the pure eyes of equity, the suppressio veri is as great, if not a greater wrong than the suggestio falsi. And this, I have this bracketed, and equity stops him who should have spoken and did not. Does it not declare that he that doeth iniquity shall not have equity, and
mm-hmm.
give iniquity the broadest meaning, as covering not only actual fraud, but deceit, concealment, and any unconscionable act by the party seeking equitable relief as to the subject matter? So that right there, I think, really shows what the the ultimate goal and aim of not only equity but equity jurisprudence is they're going to presume that everybody is acting the way that they
Hmm.
should be, and they're not going to presume wrongdoing unless wrongdoing has been absolutely proven. So
Yeah, I love that. I love that. While it abhors fraud, it never presumes fraud. And unless fraud be clearly proven, the presumption of honesty and good faith must prevail. And I love that because the law courts are the exact opposite. You go in there and they are assuming you're guilty, and you have to
assumption and
prove your
presumption all day
innocence.
long.
Yep.
Yep.
Yes, assumption and presumption all day long. And you have to prove that you're innocent. And equity
Yes.
assumes that you're innocent and you were trying to do the right thing. They're two, I mean, just the stark contrast becomes more clear and more clear as we go through all of these cases. It's
Yes. I
amazing.
mean, equity looks at the substantive right and, kind of the root cause analysis of everything, where law is going to assume and presume, and you're only there to decide what degree or to what degree you are guilty. Not if you are or if you're not, but it's to what degree are you wrong.
Yeah, which that seems like a Jesuitism right there for sure.
Yes, it's, pick one, wrong or more wrong. Which one you want?
Right. Yeah, nice casuitrist.
Yeah.
Kazoo right there. Yeah,
So
amazing.
I'm going to continue on here. The morality of these maxims and of the court of equity is not the morality of the world. That of a court of equity is more refined, higher,
Mm.
broader, and purer than that which prevails among men. The man of the world sees no harm in exacting his pound of flesh, if it is so nominated in the bond. He has no scruples about exercising any right that his contract or the law gives him, even though it unnecessarily ruins his adversary. Nor does he consider it material whether he exercises such a right vindictively, in bad faith, or in good faith. His conscience is easy if the law gives him the power and authority to do the act.
Hmm.
That is that I think is worth thinking about. That there are a lot of people whose conscience and morality are guided by the fact that someone told them they're allowed to.
Yeah, yeah, absolutely.
They don't have to
Absolutely,
think for
man.
themselves. They don't have to go through the moral reasoning. They don't have to make compromises or concessions or do any sort of mental effort whatsoever. They can, without reservation, do whatever the law says that they're allowed to do. And it doesn't matter if it's done vindictively or if it's done to ruin the enemy or what have you. If it's done in bad faith, if it's allowed, they'll do it, which is why
And
it's important to learn equity maxims, because there are people
mhm.
out there like that. And if they come after you, you got to have recourse to another venue or jurisdiction in order to protect your rights.
Yeah, yeah, that's absolutely right. Because on the and I love that you brought up that point because that is exactly right. People base their morals on what they're allowed to do, which means morals aren't actually brought into the question. You're just you're obviously not reading your Bible if that's how you live
No,
either, because
it's
that's
for a
go
lot of
ahead.
them, it's like, they're excited because now they get to go to the playground where there are no rules, and they love that
Yes.
playground,
Yep. Yep.
you
Yeah, they
know.
do. They
And it's
do.
just to me, it's sort of still a remnant of that childlike mind that says inside this square I can do whatever I want and I can't get in trouble,
Yeah.
you
Yeah,
know.
and I mean, I mean, we could get into some crazy shit with that because I mean, did you know about the whole Epstein trying to start their own country and shit?
What?
Well, yeah, dude. Oh, what was it? What was it called? It had some maritime law name to it too. Uh, oh, I can't remember what. Dude, it was crazy. It was crazy. They were literally trying to start their own country and stuff. To
Wow.
basically do whatever they want. And and that's the whole mentality. That's how far this stuff goes. If you let morals go out the window, that's my whole point to it. Is if you let the Talmud be your moral compass, then your morals are not correct. I'm just gonna say it, that, and
Yeah,
that's and that's all there is to it. But if you use other authorities like the Bible, your morals are going to be correct. And I'm sorry, those are just the facts of the situation. If you don't believe me,
no.
you can go read the Talmud for yourself and
That's
just be.
that's crazy. I did not hear that. I mean, what are they going to call it? Babylonian bathhouse bonanza?
What was the name of that? Mara something, Mara Mara, Terra Mara, Terra Mara.
Land, water?
Land water, land of water. Yeah, that's what it was. Terra Mara.
Wow. Well, I guess that could be the land where the law of water reigns supreme.
Well, I was just gonna say that because on the high sea you have no God-given rights.
No, because there's no land upon which to plant your feet. It's anyone's game.
Exactly. Exactly. So Terra Mara, the law of the land of the sea, I mean, it seems like that's what they were going for. Yeah, I
Great.
didn't. Yeah, I know it blew my mind too. I was like, fucking
Are they
what?
gonna get a are they gonna get a seat at the UN too?
I mean, I think they were I mean, they were legit trying to have that. Like, it's not all these other people out here just trying to make their own nation so they can just be left alone in their own fucking house. They were trying to get like a spot at the UN and, actually have like government authority and shit.
Wow.
Yeah, yeah, it's insane. It's absolutely insane. Yeah. Anyways, we don't need to talk about fucking Epstein. Uh,
Yeah, because we're talking about equity and purity.
yeah, yeah, we don't need to get into any of that stuff. I don't even, yeah, yeah. Maybe one
All
day
right.
we'll do a show over all that stuff just because it's connected to the Vatican and that's what I'm really interested in. But yeah.
Yeah. Oh, we should do a show on Vatican assassins. That'll take 6 years.
We'd never make it through that book.
We,
God.
yeah. Eric John Phelps, 2,000 pages. We're gonna cover that book and give commentary on it. It's
Yeah.
like,
No, we'll definitely draw heavily off of it though, because I'm sure we're going to do plenty of shows over the Jesuits.
oh, I'm sure.
Yeah.
Well, I'll continue on here. So the last thing we read here was his conscience is easy if the law gives him the power and authority to do the act. Soon after I went upon the bench, a case came before me as chancellor, which more strongly than any I have had since illustrated. Wait, sorry, let me read that again.
Yeah,
Soon
he
after
worded
I
that a
went
little weird.
upon the soon after I went upon the bench, a case came before me as chancellor, which more strongly than any I have had since illustrated the difference between the morality of a court of equity and that which prevails in the business world. It was 1880, and the case was a bill for an injunction and relief brought by the Atlantic and Pacific Telegraph Company against the Baltimore and Ohio Railroad Company and the American Union Telegraph Company. The complainant telegraph company, without written contract, had been, since 1870, under a verbal arrangement with the Baltimore and Ohio, accompanying with its wires and part with its poles, the right of way of the Baltimore and Ohio Railroad Company for the purpose of the joint business of its own and of the Baltimore and Ohio Railroad Company upon certain terms as to expense, etc., agreed upon. The Baltimore and Ohio Railroad Company, on the 28th day of March, 1880, gave notice that the arrangement with the Atlantic and Pacific Telegraph Company was terminated and that it would take possession of the wires and poles, etc., on the 1st of March following. This it did in a clandestine manner of an important part of the circuit of the Telegraph Company, and on the same day it took possession, it entered into an arrangement as to the use of the wires in the transaction of the telegraphic business with a rival telegraph company, the American Union Telegraph Company, a co-defendant. Yeah, so that's a lot there.
Yeah. It's
Yeah, so basically you got several companies sharing electric pole space, and there's a railroad involved under a verbal agreement, and someone terminated it without notice.
yeah.
So the court held that under the verbal contract, the Baltimore and Ohio Railroad Company at law had the right to terminate the verbal arrangement and take possession without notice of the wires and poles upon its right of way, but that this legal right was to be exercised with the proviso that underlies every right in every contract in a court of equity, to wit, that it was to be exercised in good faith, that under the circumstances in evidence there was an attempt to exercise a legal right in a harsh and unconscionable manner, and that the exercise of the right for the joint benefit of itself and a rival telegraph corporation was not the exercise of its legal right in the good faith required by a court of equity. I cited upon that occasion the opinion of Vice Chancellor Wood in Blissett v. Daniels, where he enjoined an action dissolving a co-partnership, the articles of which provided that 2/3 of the partners should have power to expel any partner from the firm without cause, without a convention of the partners and without previous notice by serving a notice of expulsion signed by two-thirds of the partners. One of the partners had quarreled with the complainant and had induced the other partners to join in the notice of expulsion. Sounds like revenge and retribution there.
Yeah, yeah, for
So,
sure.
upon the ground that the power of expulsion was used for the benefit of one of the partners with whom the quarrel was had, and that the assent of the other partners was obtained without notice to the complaining partner, and therefore the power of expulsion had not been exercised in good faith, the vice chancellor held that the act was a fraud upon the complaining partner in a court of equity, whatever it might be elsewhere. The vice chancellor then added in words that I wish might be, as to the standard of morals there laid down, burned into the memory of all solicitors of this court, the following quote, as has been well observed during the course of the argument, the view taken by this court with regard to morality of conduct among all parties, most especially amongst those who are bound by the ties of partnership, is one of the highest degree. The standard by which parties are tried here, either as trustees or as co-partners, as in various relations which may be suggested, is a standard, I am thankful to say, so far higher than the standard of the world. And tried by that standard, I hold it to be impossible to sanction the removal of this gentleman under the circumstances. End quote.
Mhm.
It may justly be claimed that not all of
Oh,
the
you can stop
chancellors.
there.
Oh, sorry, that's
Yep.
yours.
Yeah. Yeah. You can stop. Yeah. Yeah. It goes into a different subject there, but I really like this part because this is a great example of the maxim equity follows the law and how it doesn't actually follow the law, but it more. I think it was you that gave me the example of more of it follows the law of a sense of the law is a dog and equity is the owner on the leash. And just like in this case where somebody's trying to use the law to basically screw over somebody else, equity comes in and says, I don't think so, buddy. Hold on,
Yeah,
buddy.
hold on.
Slow
It's like
down.
the in order for you to act on the dog, the dog has to kind of act up in order for you to try to get it under control with the leash. If the dog's not doing anything, there's no reason to, I don't want to say jerk the leash back, but that's kind of how equity views it. It's
There's
like,
no
well,
reason to guide the dog. Yeah,
yeah, there's
yeah.
no reason for me to re-guide the dog at this current moment because it's following the path, it's staying on the sidewalk, it's doing what it's supposed to do.
Mhm.
Equity or the owner is only going to intervene when it needs to rein the law or rein the dog back in.
Yeah, yeah. I mean, I do think Tuley talks about this when we cover that maxim. But yeah, I just think that's such a great example because I just saw somebody on Facebook talking about all this stuff too, and he's talking. It was actually in reference to this maxim. And I was like, you don't understand the maxim because he's like saying that equity is like it goes by these rules, and you have to go by the federal rules of civil procedure because equity follows the law. I'm like, you don't get it. But I
You
said,
know,
look. I said, listen to my podcast if you want to understand. So,
Yeah, and here's the thing, it's like, in order for you to get a remedy in equity, you have to exhaust your legal remedies at law. And so if
exactly.
you go to the law side first and you're unable to get remedy, okay, what follows? Equity follows. Now you go into equity. And so it could be a grammatical structuring as well with the term where it's not that equity follows the law in terms of equity is following the doctrines of all law. It's that equity comes after law has been insufficient. Equity comes in after the law has been deficient by reason of its universality. So it's
Right.
like equity is what comes next when you've hit a barrier in the outlaw side. I think that's kind of what the spirit of that is.
Yeah, yeah, I agree. I agree. And it is a little bit confusing at first until you actually get it explained and spelled out. And because I do think it is a grammatical thing, and especially if you don't understand parts of speech and how they can work together, then it can be confusing. And people shouldn't feel bad about that because there's even law professionals, and I mean I'm talking about legendary law professionals that have written books and are historical figures that don't understand equity and don't understand that maxim. So it does take a little bit of spelling out, but and I think this is just such a great example of that. Is that it's more like a leash instead of a bowl, I guess. Oh. But that's going to be it for that little section. So yeah, we'll go ahead and move on so we can make it through the speech for sure. So we're taking off on page 49 at the bottom. It may justly be claimed that not all the chancellors who assisted in giving the world these maxims were chancellors like Wood, More, Ellesmere, Lord Eldon, and others who adorned the chancery bench. Of Lord Eldon, it is said, as should be said of as every chancellor, quote, he had a disinterested and passionate wish to decide rightly, an earnest desire to do justice between man and man, end quote. It must be admitted that there have been some chancellors whose administration of their judicial office and whose private life were a variance with the kind of morality and purity I claim for the court of equity. In the name of the wisest, brightest, and meanest of mankind, Lord Francis Bacon suggested itself as the most noted of such chancellors. It is a historical fact that Bacon was accused of bribery in administration of equity, committed to the Tower, and deprived of his high office upon his own confessions of guilt. Notwithstanding his confession, there are many of his admirers who do not believe him to have been guilty of the greatest of all crimes, that of murdering justice in her own home. Parks, in his history of the Court of Chancery, says, as to the charge against Bacon of bribery, many extenuating facts could be collected, and much extenuation could be pleaded, end quote. It is true that he was probably the most distinguished man that ever held the Great Seal of England, and that he was one of the greatest ornaments and benefactors of the human race, and yet there is but little evidence, aside from the celebrated ordinances and chancery, to show that he was entitled to the rank among the greatest chancellors by which decision those pure and grand equity maxims have been created. Wow, interesting. Notwithstanding the fact that he claimed and probably did make an average of 2,000 decrees and orders in a year, geez, yet it is a singular fact that not one opinion of his has been handed down to posterity. And I find that interesting. I didn't actually know that Francis Bacon was a chancellor, but um
And that not a singular fact that not one opinion of his has been handed down to posterity. I wonder why that is.
well, apparently it's because of bribery.
Do you
That's what
think
I
that
would
is what it
assume.
is? Because he
Yeah.
disgraced his office, everything he said up to that point is not quotable.
Well, and I mean, yeah, I think maybe he gets into it. Hold on, let me read this last paragraph into the record, and because I think he gets into this. It is true that the moral tone and standard of which accompanies the administration of equity must be dependent to a large extent upon the moral purity and conscience of the chancellor. He must have not only integrity of character himself, but he must so conduct himself both upon the bench and in private life, that all who appear before him will have confidence that such integrity will control all the acts done in discharge of duties of his high office, the highest and most responsible office upon earth. In the administration of equity, the conscience of the chancellor, to a large extent, must be the rule and measure by which he must measure the conscience of the litigating parties. So yeah, I think that is what it happened. It's like, even because there's still people that say he was innocent of the bribery, but even so, even if there was a question of it, I think they removed all of his decisions, and not one of his decisions has been handed down to posterity because of the just the accusation of bribery.
Yeah,
Is
and it
the
shows
way
it's
I
like, well,
understand it.
if you were, it's like, how do we know that any of the other opinions or any of the other decrees that you handed out may have been based in the same thinking that led you to bribe somebody?
Yeah, yeah,
Oh,
exactly.
that's
And
unfortunate.
yeah, yeah, that is really unfortunate because I bet there was some really good stuff in there. But I do like the fact that this is actually the exact opposite of the clean hands maxim. It's like chancellors do have to have clean hands and integrity in every part of their life if they want to be a chancellor, but the people they're adjudicating over don't. They only have to have clean hands in that particular case. So I think that's pretty interesting, and I think this goes to right the heart of what these law guys say about they don't trust the judges. And let's like, well, I guess if you're saying that, you just really don't understand how the court systems are working today. Because if you did, you would understand that the judges are under a military jurisdiction. They're not under admiralty and all this patriot nonsense bullshit. It's a military jurisdiction, and they have loyalty to the commander in chief. And for them to go against that loyalty and break that oath, it is literally treason and punishable by death. And the only reason and the only way they can get around that is through a court of equity. If I'm understanding that right, is that how you understand it, Whitestone?
Yeah, I believe so. Yes.
Okay. Yeah. So I'm just really trying to make the point here because I just see it so much online. What's that?
Nope, I didn't say anything.
Oh, okay. Sorry, I thought I heard something. But yeah. Anyway, so yeah, that's my little. I'm kind of on a pedestal today, but maybe I'm a little annoyed. But
No, I mean
yeah,
we could talk for a long time about the things that go on online and a lot of the different schools of thought out there. But most of these people, they just wildly throw whatever they can at the wall, and if it sticks, great. If it doesn't, they use it anyway.
I, yeah, that's what it baffles me, man. And like a lot, I
Yeah,
think a lot of it is like some people do get wins in the military jurisdiction. But the thing about people getting wins in the military jurisdiction is in no way, shape, or form is it repeatable. It's a one-off thing where the judge just wanted this person out of the court because they're just fighting, 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 and they won that battle. I'll give them that. They won that battle, but it's not repeatable. You can't say I did this and this and this and prove it, unlike you can when you go into equity. But yeah,
yeah, it's not
anyways,
like you can't because the thing is once they realize that someone has figured out the levers in the machine, they change how they do things so that you got to figure it out again.
exactly, exactly.
So,
Yep.
but equity is not that way. So
Right.
that's
These levers
why
have never been changed.
they've never been changed. They may have been put in a different room. They may have been installed on another machine, but the levers themselves are still there. They do work. You just have to know how to access them.
And they're made of gold.
Yes, hard to miss.
Hard to miss. All right. Yeah. All right.
All right, so moving on. It would seem impossible that pure equity should emanate from an impure source, like we just said. Pure
hmm
equity cannot long be administered by an impure mind, any more than fraud and truth can peaceably cohabit together. The selfishness which characterized Bacon and the intrigues and corruption by which many like him were surrounded, and which caused their downfall, only demonstrated the fact that absolute perfection is not to be expected in any human being. Every man who undertakes to administer equity should be able to ascend the equity bench, leaving at the foot of the steps that lead to it his own personality, his prejudices, his likes and dislikes. In other words, leaving all his human frailties behind him. And I have this section bracketed. I contend that no one, be he judge or student of equity, can give himself up to the earnest study of equity maxims and the science of equity as one who loves his profession should, without becoming not only a wiser, but a better and purer man. Such study of equity maxims and jurisprudence quickens the perceptions between right and wrong, brightens the conscience, and elevates the entire moral character. In other words, it ennobles the man beyond, far beyond, the study of any other known science or profession. A Chief Justice of England once remarked that law was a coy mistress. She would bear no other wooing, and that remark is peculiarly applicable to the study of equity. The student who wishes to worship at her shrine must not mix with his study any other pursuit or business, but he must
hmm
give himself up heart and soul to his task, and never falter or weary in its pursuit. He must study equity as one studies a foreign language. He must study its history and learn the root or source from which it is derived. He must fully understand its construction and principles, and by continued application become so imbued with its spirit and become so fully a master of the language that without effort on his part he thinks in such foreign language, and then and not until then can he claim to fully comprehend it.
I love that, dude.
Yeah, beautiful. Absolutely
Yeah.
beautiful. And it's very true.
Yeah.
That section that I had bracketed where the study of the equity maxims really does quicken the perception between right and wrong, brightens the conscience,
hmm
and elevates the entire moral character.
I believe, yeah, we've talked about that. We've talked about this through the whole series too. That's
Yep.
I say it all the time. And I do and I agree with what he says here is but basically to put it in modern day terms is like this isn't a cute thing you do on the weekends. This is a way of life once you
Yes.
start getting into this thing.
This is a second full-time job, folks, learning equity and studying and the whole deal.
Absolutely. But once you get into it, it doesn't feel like a job because it
No.
feels good to study this
Yes.
stuff. It
I when
just
I first Oh, sorry, go
go
ahead.
ahead. No, you go ahead. Go ahead.
Oh, I was gonna say when I first started studying equity and I started looking at, I was like, the words were foreign,
Mm,
and a lot
hmm
of it was just words, and I didn't quite understand it until at that time started getting tested by the system in certain aspects, and you realize very quickly what those words mean. And now, 2, 3 years later, here I am at 10:30 at night, happily falling asleep with my face in a book at the kitchen table
So happy
because
about it.
yeah, you
Yep.
want to stay up and you want to read and you want to learn, you want to figure it out, and it's 11 o'clock, you got to get up at 5, and you just want to continue reading about subrogation. It does happen.
Yeah. It absolutely does. And another thing that has happened to me is ever since I've started reading this, it has just drawn me so much closer to the Bible and actually
Absolutely.
understanding the Bible in a better way too, because all of these principles come directly from the Bible. So you're reading these things side by side, and it just makes more sense. And like we went
Absolutely
through the
does.
verses last week on John 1, and it's if we weren't studying equity and the passage where it says, Moses gave us the laws, but Jesus Christ gave us truth and justice. If you're not studying equity, you don't understand what those words mean. But
Yeah,
since
it's
I'm
law and
studying
equity.
equity, you go ahead. Yeah.
Law and equity, that's what it is.
Yeah, 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 it's the and seeing that distinction all the way back, and this is I read the 1560 Geneva Bible, the Bible of the Protestant Reformation. So all the way back then, so it just solidifies everything for me. This is nothing that can be changed. God can't be changed. And I mean through the you find redemption through Christ. I don't know what else to tell you. If you read these things, then that's what you're going to learn. And then I've never been happier in my life. That's all I'm going to say about that. So I could
Amen.
go off on the Bible for yeah I could go off for hours, but yeah we'll just leave it there. I've never been happier than when I am studying this stuff. So. But we're running out of time here, so let's get this last little bit of the speech on the record. This is the last 2 pages, and this is where Tuley gives us his warning about merging law and equity. So, everybody listen closely. And this is going to be a great little shipping off point for the second hour because we are going to get into this exact concept in the second hour that you can find at truelifeproduction.com. Click on the banner that says the Learning Out Loud podcast. Go to the foundations page. That's where you can get the full 2 hours, all of the show notes, everything we talk about on the show. So, with no further ado, let's get this last little piece into the record. So, the consolidation of law and equity. In conclusion, as to the consolidation of law and equity, I would say the tendency of the times is to consolidate the two jurisdictions, law and equity, into one. In our state, which takes its jurisprudence from the separate system, law and equity of England, no greater mistake could be made. No greater mistake could be made. I am unalterably opposed to anything like a code system. Law and equitable jurisdictions are so radically different that any attempt at a combination of the two into one system will be injurious to both and provide no sufficient substitute. The wisdom of ages has developed them separately. They are, in fact, almost as different in their methods as daylight and darkness. Which I would not, I couldn't agree more because I see it as military and equity. Those are the only two jurisdictions there are, and that is
Yeah,
daylight and
darkness
darkness.
cannot sit in two thrones.
Yeah, exactly, exactly. With the progress made in the law by its adopting equity principles, thereby softening its rigor and enlarging its scope, no difficulty is found in maintaining each within its proper sphere. with the bounds and limitations of each clearly defined. To ambig to amalgamate them could only, excuse me, to amalgamate them could only produce confusion as to the principles and rights governing the contention of the parties. It has an injurious effect upon the magistrate who attempts to administer them. It spoils the good common law. It spoils the good common law judge and ruins the equity judge. The equity judge, in the course of time, would disappear from the judicial arena because the inevitable effect is that a judge dispensing an amalgamated jurisprudence soon loses sight of the distinctions between law and equity, and precedents come to govern rather than principles. It's
Man, that is
dude.
pointed.
Yeah.
That is
I mean,
seriously pointed.
yeah, he could not have called it better. It was like he could tell the future, man, because that is exactly what is happening today.
Well,
And
he even going back, we were talking about Bacon. It's that corruption by which many like him were surrounded, which caused their downfall, only demonstrated the fact that absolute perfection is not to be expected in any human being. And now you're putting that human being in two chairs, looking at law and equity concurrently, and then losing the distinction, and it's injurious to both.
I, absolutely, man,
You can't put a
absolutely.
human being up there who's faulty and expect them to look separate ways with both eyes at one time.
Yeah. Yeah, man. It's just what a concise little paragraph right there and so relevant to what we're living in today. I love it. So the common law judge's first thought when a question is presented is there a precedent? And it becomes his habit. While the equity judge first questions while the equity judge, the first question that presents itself is what principle governs the case? As it is easier to follow precedents than to apply principles, there has always been a judicial tendency to seek and follow precedents. I do not underrate the value of precedents, but I realize that there was some great wisdom in Lord Bacon's advice to judges. Set it down to thyself as well to create good precedents as to follow them. The decision in the code states generally have a decided character as, quote, case made law. An equity judge in searching for the right never goes to the decision of the code states until he has exhausted the decisions of those states that have kept the two jurisdictions, law and equity, separate. But if, in the demand for the so called reform in the administration of justice, we must have the code system, and the two systems must be amalgamated into one, let us at least endeavor to secure the adoption of the provisions of the English Judicature Act. In substance, that all cases shall be decided upon the principles of law and equity, and wherever they conflict, those of equity shall prevail. He couldn't have ended this speech in a more relevant, pertinent way to how the law system works today. And I mean, he obviously saw something coming down the pike. He understood something that I don't think a lot of people understood at the time.
Yeah, they were kind of setting a all the states were setting a precedent for merging the jurisdictions, and he said that's not a good idea. And then a lot of these he's like Kate, what did he say? He's not a favor of a code system.
Yep.
It was telling his judges, it's like, don't just follow precedent, but conduct yourself so as to create good precedent. Because it's much
Yeah.
easier to just find a precedent and follow that. But use your equity eyes and try to create a good precedent rather than just seeing what's on the list and pick one of them.
Yeah, yeah, I love that. And this is for all those law guys out there that say equity is judge-made law. He's saying the decisions in the code states generally have a decided character as case-made law, which is judge-made law. That's exactly what it is, and that's exactly what an Article 1 court is. That is judge-made law. And
Yeah.
that's like, so what everybody is thinking is equity is actually what they're dealing with. That's
Yeah.
actually judge-made law. So it's like
And there is
everything.
such a thing as discretion. Like, yes, judges have discretion and they can use discretion because they're actually pulling out of the equity side and using their discretion. And
Right.
that's not necessarily them making up laws. That is them using their discretion to see if you actually have a just claim, to see if there was good faith, to look at the aspects of the case and decide it on its merits. So that's different than them just arbitrarily making law.
Yeah, yeah, absolutely, absolutely. Oh shoot, I had a point. I forgot what. Anyways, we're at the end of the show right there. I think that's probably the best place we could leave it, anyways, because these things that we talked about right here, this is from 1903. That's when the speech is from, and we're going to talk about a case from 1999. Grupo Mexicano de Desarrollo v. Alliance Bond Fund Incorporated 527 US 308. And that case is going to address exactly what the end of this speech is talking about right here. And they will actually even put it in the language of post-merger. Because in 1938, they tried to merge all these things, but as we will learn, they were unsuccessful in their task because you cannot merge equity. So if you're interested in these things and anything else that we talk about, please go visit truelifeproduction.com. Check out All Aboard, check out our Article 3 articulations, go to the foundations page so you can get all of the extra stuff like the Supreme Court cases we've talked about, all of the sections in the Pomeroy books, the story books, all of that stuff. Anything we've talked about, you can find there. Dig through it for yourself and start learning together on the Learning Out Loud podcast. So, with no further ado, never forget to seek truth and honor the Creator above all, and let that be the whole to law.
That's the important thing here, is that everyone's word should be meant for a use.
And the words that I'm using today are meant to pull down idols within people's temples.
Meaning that I want to destroy
Falsities that they have idolized.
for their entire life.
And just pull those out and sweep them clean. And before that temple,
And get reinfested with a new lie. Give it true life.